Good afternoon. The pressure is on now that lunch is actually in the room, so I'll try to be quick, and I'm short enough that I'm going to actually move down a little bit. I want to say thank you to Rosanna and to Guido and to all the folks in the Scotland Committee for allowing an interloper who's just visiting at Glasgow to come and join the conference, and this has been a really great experience for me. You'll see that I have no slides, so this is my micro protest against the resort to technology. So I'm just gonna chat. You'll also see that my subject matter deviates a little bit from what we've been seeing here, a lot of big copyright energy, so I apologize to the non-lawyers in the room, but I will assume that no one's read the paper or knows about the project, so I'll talk about the concepts that you need to know through it. And I'll say that at its core, this project is really about presenting some of the ways in which technology allows copyright holders to get away with shenanigans, right? And so in the project, I talk about a couple of different types of shenanigans that people can get into, and I'll go through some examples here. And the examples that I'm going to pull from are based off things that are going on in the U.S., and some of the interventions that I call for consider particular U.S. statutory sections or actions that U.S. Congress could take, but the parallels between the problems, the issues, and the sentiment are reflected similarly in the UK and in the EU. So I will look forward in Q&A as well to suggestions on other examples we could pull from there. The project gets its title, of course, from the Hans Christian Andersen fairy tale, where we see the hopelessly vain emperor tricked into parading around town in his birthday suit by two fraudsters who tell him that he's wearing a robe spun of gold. And the climax of the story comes at the end when a young child, shouts out the truth and exposes everyone's foolishness. So this project really aims to expose some of the foolishness that technology has enabled here. And I began, as I often do, by looking through various industry blogs and keeping track of deals or deal aspects that were surprising. In many cases because they either claimed to involve a copyright but clearly didn't, or they were seeking infringement or some sort of licensing fee where none was owed, right? That the copyright statute would allow fair or free use of. And ultimately I concluded that despite having no relevant connection to the copyright statute itself, the practices that I was observing all explicitly relied on its existence, right? The Copyright Act, as enacted and we see it in practice, is so convoluted and confusing to the average user that if you tell them they're committing copyright infringement, they'll just assume that they are, right? Or that they need a license for something, they'll just assume that they do. And given the incredibly steep possibility for punishments that we have statutory damages. So first, copyright strict liability, right? So whether you intended to infringe or not, you're on the hook. And then statutory damages range from, to add to confusion, $750 per infringement for accidental, up to $150,000 per infringement for willful infringement. So given the potential for damages, people, generally speaking, don't want to mess with it. And it leads to some pretty inefficient practices. And I call for in the project different ways in which the government might be able to help mitigate these somewhat. So what are these potentially problematic practices? I break them down in the project into two broad categories that I call faux copyright, which is just what it sounds like, right? Fake copyright or over-claiming copyright where you don't actually have one. And the other category I call monetized non-infringement. And this category of practices, as the name suggests, entails making money out of nothing, right? Someone doesn't infringe your copyright and then you charge them for the privilege, right? And that's effectively the sorts of things that we have going on. The faux copyright's a little trickier to address, and I'll talk about why in a moment, but the monetizing of non-infringement, I think we have some more promise for things that we could do there. I want to make one quick point of clarification before I go on. So the example that I'm going to talk about today, and most of the examples that are in the paper, are the result of some form of or other of private ordering. So I don't mean to suggest in this project that any form of private ordering, including that which circumvents the Copyright Act and results in extra statutory revenues, is problematic. In other work, I talk about how efficient I think this is and how lawmakers can take lessons from this and ways to improve the law. But in these particular circumstances, as I hope I'll demonstrate, I think we could have a problem. So. The draft that I present offers a lot of different examples. I'd like to discuss one in particular, in part because it ties in and builds on a lot of the things that Aline was talking about in her work. Many of the deals that I discuss in this project involve a powerful platform using its position to effectively override or circumvent statutory law and often congressional intent via this private policymaking. And so I'm going to use YouTube and its content ID system as I think, a really good example of this. And for the non-copyright lawyers in the room, all we really need to understand to follow along in this example is that fair use is this big doctrinal exception to copyright infringement, right? Fair use would allow a use that's otherwise unauthorized or unlicensed, use of copyright material as long as it meets these certain standards and requirements to not be copyright infringement, meaning it can be used freely without permission or a license. And mercifully, for our purposes, the specific four-factor test that's currently in the Supreme Court being challenged at the moment, we don't need to know any of those specifics. All we really need to understand is that if a use is fair, then it doesn't infringe. So YouTube, as we all know, is the world's largest music streaming platform or content streaming platform more broadly. Interestingly, also the largest music streaming platform, since it's not a music streaming platform, but it is the one that's used most broadly. And unlike many of the other content streaming platforms that we're familiar with, like Spotify or Netflix, YouTube is unique among the group of content streaming platforms in that it allows users like you and I to upload content. That's user-generated content or user-created content, UGC. The long story short of this is that tons of infringing content then gets uploaded every day to YouTube. People posting pictures of their children or cats dancing with music in the background, which they do not have a license for, right? So that's this UGC that became a big concern. And in 1998, the US Congress amended our Copyright Act to include this infringement safe harbor for platforms like YouTube who allow users to upload content that will invariably infringe so that they could continue to operate without the fear of crippling copyright infringement liability. And in order to take advantage of the safe harbor, a platform has to set up this system by which they will accept notices of infringement and a means of responding to it, right? This is the takedown and notice system that you may have heard about. YouTube dutifully did that. They set it up and more or less found themselves faced with hundreds of thousands of such complaints, right? The latest transparency report updates that to several million a day, right? So the armies of people that they hired to take these things down couldn't do it, and they certainly couldn't keep them down, right? So eventually, YouTube and the understandably very unhappy content owners got together and reached this private agreement in which the major content owners would upload all of their copyrighted material to a bot, to an algorithm, to an AI, and that bot would crawl the site continuously looking for matches, and where it found them, it would give the users an option. So on the one hand, the user could take the content down, which is what they could do under the statute, or, and this was really the move of Content ID, they could opt to leave it up and just monetize all of the advertising revenues that were served around the video. So not surprisingly, the overwhelming majority of content owners, like literally over 99% of them, opted to go for the latter, right, opted to monetize. And this arrangement is called Content ID, and this private arrangement, not the statute then, is what governs the relationship between the major content owners and YouTube today. But importantly, all of the content ID signatories, the major content owners and YouTube, Google in this case, the parent company, they forego the statutory safe harbor, which means they're not beholden to any of its requirements, one of which would be to make sure that before you issue a takedown notice, you've done a fair use analysis, right? The bot doesn't conduct a fair use analysis. It just monetizes content that perhaps doesn't infringe because it's fair use. That is the quintessential example, I'm going to say here, of monetizing non-infringement, and it's done through private ordering, and the private ordering is legitimate because they can move around the statute. And the problem, I think, here is that in many ways, it sets up a practice, right, that wherein users just assume that they can post any kind of content they want, right? So we're not educating the users in any way about copyright infringement. And the content owners just assume that they can make money off of any posting of their content, whether it's fair use or otherwise, right? So this is clearly beneficial for the content owners and beneficial for YouTube, but it is not consistent with the rights that we've given users or what the statute's trying to do. Okay, so one of my biggest concerns here is that whether it's done in absence of statutory rights or in misuse of them, this kind of monetized non-infringement and faux copyright can result in inefficiency, right? So, for example, the Content ID agreement that I described allows content owners who already get the statutorily dictated royalties, right, and whatever they've negotiated, and these advertising revenues on top of it, this additional revenue stream, it doesn't require them to produce anything new, right? Instead of, so this is textbook rent seeking, right? Instead of redistributing monies away from small content owners, they could be developing new bands that would produce music for all of us to enjoy, et cetera. So it's not the most efficient use of their time. In other words, we have this algorithm, Content ID, that is governing copyright infringement, sort of, on YouTube. But there's no regulation of the algorithm, as Aline was emphasizing in her presentation. And that's because this is a result of private ordering, which in the US is really hands-off, right? Like, we don't touch private ordering. This is something that people can do, and there's very little to no evaluation of it, right? Even attempts to push for transparency, which is one of the possible solutions Aline highlighted, have been pushed back on for anti-competition reasons, right? The algorithms are proprietary, and so of course we can't give them to you. And in any event, the algorithms are simply reflecting the preferences of the users, right? The reason popular music is getting served more frequently than little obscure band is because it's popular, right? And that's what people want to hear. People really have quite homogenous musical tastes. You don't really want to hear new music, right? You want to hear the music that your friends are listening to, and the algorithm knows it, right? And so what do you need? Okay, so my argument here is that all of these outcomes potentially contravene copyright's goals, right? And so to the extent that that's problematic, I go through in the paper and I propose a few different possible interventions. I'm going to skim them quickly here from sort of path of least resistance to most unlikely to actually happen. So path of least resistance would namely be amending the Copyright Act. Not my favorite option, mostly because I think this is a bit of, patching a dam with bubble gum, I think is what they say, a bit of whack-a-mole. There's always going to be a new technology and a new thing that we haven't anticipated, and whatever little amendment we make may not work. But if I had to endorse one amendment, there's a section in the U.S. Copyright Act, Section 506, and that section establishes civil penalties for falsehoods in a copyright notice and in copyright registrations. But it's currently too narrow to reach false copyright claims, but that seems like a reasonable enough and easy enough fix, so maybe that could get rid of a lot of faux copyright claims. A longer lasting solution might be for the government to introduce something we're kind of calling like truth-telling regulations. These would be either prohibiting misrepresentations or omissions or mandating disclosures around whether or not what you've got is actually copyright infringement. None of these interventions, of course, will really impact problematic behavior and imbalances that and these things that owe to power imbalances, right? And so for those sorts of problems, we suggest that we'll probably need more structural interventions like antitrust. But for a lot of the other smaller problems, we think they can probably be taken care of with disclosure requirements. So I'll end by saying, are these practices, this faux copyright and monetizing non-infringement, really a cause for concern? And I think that the answer is an emphatic yes, right? And I think that the reason is because when they're taken collectively, these practices can really hinder copyright's ability to do what it's supposed to do. Why? Because it sets up a norm for tolerating the charade, right? To go back to the metaphor, it tells the townspeople to avert their eyes or be thought foolish. For example, if one user on YouTube agrees to forego their right to fair use by click wrapping the terms of service and posting their content, then the next user does, and so on. And because YouTube is so incredibly dominant, the industry norm for streaming platforms becomes no fair use on streaming platforms. That directly contravenes what we're trying to do with the law, and I think it makes for bad policy. So what I hope to do with this project is encourage both lawmakers and folks in the industries to recognize these practices as not always harmless and to mitigate them where they can. So thank you so much for your time and attention. I'll let you go eat lunch now.